Hello, friends and clients of JLW Immigration Law Group. I am Jennifer Walker Gates, board certified immigration attorney. And in this video today, I'm here to talk about what happens after you file a U visa lawsuit. We have been filing U visa lawsuits here for 5 years with a lot of success. And most recently, we filed one in April of this year. And this week, our clients are getting their work permit. So I want to explain what the U visa lawsuit is and basically how the timeline works, what happens during the process, and what you can kind of expect if you have a U visa pending and you haven't yet received your temporary work permit. This is the video for you. It's really important for our U visa applicants to have work authorization while they wait for those U visas, because the U visas themselves take a really long time. That's what we're talking about today. Before I get into that, please take a moment and subscribe to our YouTube channel. We are really working hard to get subscriptions to 10,000 this year. We want to make sure that the immigrant community in the United States has access to good, trustworthy, correct, up-to-date information about how to be successful in the immigration system. So please help us by subscribing to the channel, share this video. If you know anyone who could benefit from it, like the video, leave us comments. We respond to the comments, and that's how you can get questions answered and also help us get the word out. Yes, that is what I would like you to do. Now, let's talk about U visas. What happens after a U visa lawsuit is filed? This is something I hear from my clients a lot. And first, I want to be really clear that when I say U visa lawsuit, I'm really talking about a lawsuit to get the work permit, the temporary work permit that comes to applicants for U visa while they are waiting for the U visa. It is not actually a lawsuit for the visa itself. The reason that's the case is because in the law that created the U visa program, there is a limit that Congress wrote into that law of 10,000 visas per year. That is not something that we can sue over, or if we did sue about it, it would have to go to the Supreme Court, and the Supreme Court would very likely rule that Congress has the constitutional authority to create limits on immigration. There are limits all over the Immigration Nationality Act on the number of people from different countries, the number of people from different kinds of family relationships, different kinds of workers. There are all kinds of limits in the immigration law. So I don't think that a lawsuit about that 10,000 per year limit would be successful. However, the law and the regulations implementing the law also say that while someone is waiting for their U visa, they are entitled to receive work authorization. Now, what that means is that when we file a U visa application, we include an application for a work permit that is issued temporarily to the person applying for the U visa while they're waiting for the U visa. And that allows them to work lawfully. It allows them to prove that they have lawful status and permission to be in the US. It allows them to get a driver's license. It allows them to get a social security card, all the things that they need to be able to function in daily life in the United States. And most importantly, heal from the trauma of the crime that they suffered, get their kids to appointments that need to be gotten to, get themselves to appointments that they need to get without having to worry that you're going to be pulled over, detained, and potentially deported at any minute. So those temporary work permits are really, really important. And historically, USCIS has taken way too long to issue those temporary work permits. That's what these lawsuits are about. The U visa lawsuit, when we call it that, it's really about that temporary work permit. So immigration, USCIS, just like any government agency, has an obligation to perform their work in a reasonable period of time. The law is very clear that when someone submits an application to the government, including Department of Homeland Security, they need to make a decision on that application, give a response to that application within a reasonable period of time. That is their work. That is their job. The lawsuits that we have filed have argued that taking 4, 5, 6, 7 years to issue a temporary work permit, to adjudicate a work permit application, is not reasonable. That is not a reasonable amount of time to take in order to do that work. And thus far, in the vast majority of cases, with only a very few exceptions, courts around the United States have agreed with us that 4, 5, 6, 7 years is not necessarily reasonable for someone to issue a work permit, for DHS to issue a work permit. So that is how we've been able to be successful in these suits. And what I'm going to explain now is kind of the timeline of how the lawsuits work. So the question that I get a lot is like, what happens after you file the lawsuit? Like how long does it take? What happens after that? So what happens after you file any lawsuit against anyone in federal federal court is that the defendant has typically 30 days to answer. If the defendant is the U.S. government, then they automatically have 60 days to answer. The law recognizes the federal government generally moves slower than individuals. And so they account for that in the time that DHS gets to answer. They get 60 days. Now, if they got 60 days to respond to our request for a work permit, nobody would be filing any lawsuit. They get 60 days. Usually they ask for 30 more, and usually they get 30 more. So they usually come to the plaintiff's attorney. Usually they come to me and say, hey, can we have another 30 days to respond to this? And I usually say yes, because working with their attorneys is important and having a cooperative collegial relationship is important. And in the scope of things, 30 days isn't that much. We are talking about spans of years and years here. So giving them an extra 30 days and maintaining a cordial relationship, fine. We're down with that. Now, at what we see now is that if the lawsuit is filed in a court or in front of a judge where DHS has not already been handed, their hind end on a platter, in other words, if they're in a new court or in front of a new judge that they don't know, they will usually try to fight the lawsuit. They will usually file an answer that says, we are not doing anything wrong. We have discretion to take as long as we need with these applications. These are first in, first out. There's a big backlog and we're not doing anything wrong. So this lawsuit has no merit. We're not doing anything wrong. We deny all of the allegations that we have violated the law here, and we don't have to adjudicate these applications. Now, this is what happens if they haven't gotten already an adverse ruling from this judge or court. If somebody hasn't already said, no, like it's not true, that's not correct, and you need to do something different. They get those 60 days to file the answer, and then they file a motion to dismiss. Typically, after the motion to dismiss is filed, then the plaintiffs, the people who filed the complaint, who filed the lawsuit, have a bunch of back and forth. There's a deadline for responding to their motion to dismiss. Then there's a deadline for them to rebut the response. Then there's other replies that get filed, and it's a bunch of kind of legal back and forth with a bunch of legal arguments, basically just usually through documents. Occasionally, a court will schedule a hearing and have the lawyers come in to talk about their different positions and how or why they can justify the position that they're taking. So there's lots of back and forth, and that can go on for, up to usually 2 to 3 months, not that long. And then you have to wait on the judge to make a decision. In my experience, judges take 2 to 3 months to do that. So all told, if you haven't been in front of a court before and you are just doing this, then you can expect things to take around 6 months or so. Now, if the judge grants the motion to dismiss, the judge says, yep, you know what, government's right. Sorry, complainants, y'all are out of luck. Then the case goes away. I mean, you could appeal that. You could try to go up the chain. But in my experience and what I've seen from colleagues, this has only happened a few times in a few very conservative courts around the country, but they haven't really tried to go up the chain with that. In most of the courts, the judges have denied the motion to dismiss. In other words, the judges have said, no, this case seems to have some validity. Like, it's not clear that taking this long to give these people their work permits is in fact reasonable as the law requires. And if the judge denies the government's motion to dismiss, then the case gets to move to the next phase, which is called discovery. Discovery is where both parties can ask each other questions, ask each other to produce evidence and documentation. It allows a deep investigation into the practices and policies of Department of Homeland Security. In U visa cases, it would allow us to look at how they adjudicate the U visas, what decisions were made, internal notes, emails, anything to do with the U visas, and how they adjudicate the work permits and the different parts of those applications. DHS does not like discovery. I've seen discovery from one of these U visa lawsuits, and it did not go well for DHS. They didn't look good by the end of it. There were, it's just a lot of internal government stuff. They really don't want out in the public eye. People were contradicting each other. There was a lot of questions about how and why things were prioritized the way they were. So in general, DHS doesn't like discovery. So if a judge says, I'm going to deny this motion to dismiss, and this case has merit to go forward to discovery, in my experience, that's when DHS will say, okay, we're going to go ahead and adjudicate these work permits for you now. And that's the goal of the U visa lawsuit, is to get the work permit. It's to get the temporary work permit. It's not to get the U visa. Again, that's not really possible. It's to get those work permits so that people can move on with their lives and begin building their lives, putting their lives back together after the trauma they've endured, and not have to worry about deportation. That is the point of these lawsuits. Now, if you are in front of a judge that has ruled against DHS. So in Austin, for example, we filed our first U visa lawsuit in 2019, and we went back and forth. The government filed a motion to dismiss. It was the first case of its type in our court. There was a lot of back and forth for several months. And then ultimately the judge said, motion to dismiss is denied. DHS, you haven't proven that this is a reasonable practice that you're engaged in, taking this long for these work permits. So for that reason, we're denying your motion to dismiss, and this case can proceed to discovery. At that point, DHS decided they didn't want to keep fighting the case, and they said, okay, we're going to, if you will agree to dismiss this lawsuit, we will go ahead and give your clients their work permit. And within just a few weeks, our clients had all of their work permits, or they had a request for evidence. In other words, some kind of request from USCIS for documentation that would prove that they were eligible for the U visa. Because again, USCIS is going to be making kind of a preliminary determination on the U visa in order to issue that work permit. They don't do a really deep dive. Sometimes we still get RFEs even after the fact, after years and years and years of waiting for a U visa. Sometimes they still send a last minute additional request for additional evidence. But during the lawsuits, they'll either adjudicate the work permit right away, or they will send a request for evidence that you can respond to. In our cases, luckily, we vet our clients before we file these lawsuits, and so we know they're eligible. We know if there's going to be an RFE. Usually we have the response already ready to go. We can anticipate these kinds of things for the most part, and the clients get their work permit pretty quickly. Again, and the case that we've just filed this year, it's only been about 6 weeks since we filed and people already have their work permits. And that's because USCIS has really begun speeding these things up. They are not waiting until the answer deadline to give us a response about whether they're going to adjudicate. They're just going ahead and saying, okay, you filed the lawsuit. We're going to go ahead and adjudicate your client's work permits. And so people are getting them pretty quickly after we file the lawsuit. This is a really wonderful tool if you are in a district in the United States, if you're in an area where either the courts have already decided this issue in favor of plaintiffs who want their work permits, or if you're in an area where it hasn't been tried, but you feel pretty comfortable that the court, based on past rulings, will make a determination in your favor. So as a plaintiff, as a potential plaintiff, as a person, as an applicant for a U visa, it's important to check with the attorney you're working with to see if they have a sense of how the courts might rule. You're welcome to reach out to us. We have colleagues all around the country that are working on these things. If you would like to file a U visa lawsuit in a district where we don't practice, we are not admitted in every federal court in the country. We are admitted in Austin and Dallas, and we are happy to file cases there. But if you're admitted in an area of the country that hasn't, that we're not admitted and hasn't admitted us, we can't get in because we don't live in that area, then reach out to us. We have colleagues who can help, and we're happy to do that. So if you leave me a comment, I'll be happy to provide referrals and potential names of colleagues that I trust who are doing this work, important work all around the United States to help people get what they are legally entitled to in a reasonable amount of time. That's the goal. Hopefully, USCIS is going to speed up their adjudications enough all the way across the board where we won't have to file these anymore. We have started to see big improvements in the speed at which USCIS is adjudicating these temporary work permits. We're starting to see them within several months of filing, and that is a welcome development. However, there are still clients who have been waiting 2, 3, 4 years for their U visa work permits to be issued. So if you are one of those people, if you're in Central Texas, please reach out to us. We will be happy to talk to you. We are probably going to be filing one more of these later this year for the clients that have been waiting a couple of years and still don't have an answer. Our position is that 2 years is plenty of time for USCIS to make a determination on a temporary work permit. So if you've been waiting 2 years or more, please reach out to us. We'll be happy to visit with you about how we could help, whether you're a good candidate to participate in this lawsuit. Some clients may have the kind of criminal background or something like that that doesn't lend itself necessarily to kicking the hornet's nest, so to speak, and drawing a lot of attention to their case. We will give you the straight dope on that, and happy to help. Please, again, subscribe to our channel, leave us a comment, like the video, and take care. And we'll see you again very soon. I hope this has been helpful, and we'll talk to you later.